They're not gonna make it, I guess.
Okay. Are they going to be in court tomorrow?
Yeah,
Okay.
they'll be there.
Okay.
Well, actually, my mama has dialysis on Tuesday, so she can't make it.
Ma'am, can you hear me?
She hung up. You could call it. That was actually my niece called from her phone, but I can call. You could call her now.
Okay. Well, again, the offer's on the table, and I want to have a discussion with them about if they make the offer, and have you present when I talk to them and you.
I'm not taking an offer.
Okay. Well, maybe after you talk to your parents and everyone, you'll have some more input. Okay. That's very helpful. That Miss Taylor has a different name. I did not know that. So I did find some impeachable offenses. Under Taylor, she doesn't have any impeachable offenses. But let me describe to you what impeachable offenses are. Anyone who has a conviction for a felony and conviction, and I'll describe what that means because it means something different than what is commonly understood, and or a conviction for a crime involving this false statement or dishonesty, whether or not it's a misdemeanor or felony, can be impeached when they take the stand. Meaning, again, Nisha, using you as a witness, let's say you take the stand. What's your last name?
Stacy.
Ms. Stacy, isn't it correct that you are a convicted felon? And if you do have convictions, you say yes. And then I can ask if you have multiple convictions, isn't it correct that you have 2 convictions for a felony? And you'd have to say yes. Once you answer those 2 questions, then I can't go into the nature and quality of the offenses. Now, if it's felony offenses and crimes involving false statement or dishonesty, then I can go into those. Now, from what I just observed, Ms. Irving doesn't have any felony offenses, but she does have crimes involving false statement, which are petty theft cases, and a bad check case. So I can use that. I can't use the assault, and I can't use the stalking to impeach her.
Even though the stalking and the battery is directly related, not to my case, but the same. She's doing the same thing she did to other people to me.
Probably not.
Why would you say probably not?
Because it doesn't relate to you.
So, are you saying probably because you could pull the discovery and the witness statement?
No, it
in
depends
those
on
cases
what your state of mind is, and that's your story. And I think I've made this point to you before, but your story doesn't sound very good to a jury. Okay, going to the wife of a boyfriend at 3 or 4 o'clock in the morning to go confront her regarding what she's doing to you sounds like aggravated battery to most jurors.
Did you listen to the 911 recording?
That's your story, ma'am.
No, did you listen to the 911 recording?
911 recording is irrelevant, okay?
Why is it irrelevant?
I'll answer that once I talk to you about your story and what you'd be testifying to the jury about. So we already have bad situation made worse by you confronting the wife of your boyfriend early in the morning, okay? Normally that doesn't happen, okay? So already the intent is going the wrong way. The intent looks like you're there to harm her as opposed to you defending yourself. You defending yourself is you call 911 and you say, I want to make a police report, okay?
With what phone?
With any phone.
I didn't have a cell phone.
Ma'am, there are phones all over the place. You can't make that argument, okay?
And how would I have gotten to make that phone call?
Ma'am, that's not going to be a legitimate argument, okay?
No. How would I make that phone call? My car was blocked in.
You don't even go to the place.
She stopped me from walking to the road. How would I?
You don't go to the place in the first place.
Okay.
You take the stand in your case.
So this is a free country, right? And this is a place that I've known, okay?
You don't go to people's houses at 3 o'clock in the morning.
She was not living there. And I didn't know at the time that she was not living there. But she told 911 that she did live there. But she instead lived at the same address she has lived till 2016, when her son was arrested for carjacking with a firearm, felony, adult felony, carjacking with a firearm. He was arrested on the 1st of this year at the age of 14. The same son that had that shovel.
So
that address, her address has never
I'm not saying this to
changed.
argue with you, ma'am.
Right, but she lied. So that's what you're going to attack. You would have to attack what she's saying, Miss Taylor or Miss Irving, whatever you're calling yourself today.
Ma'am, I'm not arguing with you. I'm just trying to point out some things, okay?
Liz, I'm not finished with my train of thought for you. Miss Irving or Miss Taylor, you told 911 that you lived on Palm Drive with your husband, Michael Taylor, Sr.
Ma'am, obviously she lives with her husband.
When in fact you lived around the corner on Sunset Drive, and you would give the house number. Is that correct?
No, people live with their husband. Wives live with their husband.
That was her own house. Her own house. She lived there. It's published in the newspaper.
Ma'am, I'm talking about your testimony, potentially.
No, I'm telling you that she never lived there.
We're having two different conversations.
To 911. We're talking about the 911 call.
No, we're not.
So you're going to have to listen to that call.
No, I'm not.
This is what
I'm not
called
using
the police out.
I'm not using it.
This is what called the police out.
I'm not supporting your...
If the officer had not showed up at 8:33, she would not have been hit in the head. This time period is an hour, over an hour later.
Is that she was hit in the head by you.
Over an hour after she had called 911.
Okay, look. I wanted to talk to you about potentially there being an offer in a case and talk to your parents too, okay? There is no offer in a case, okay? So when we go to court tomorrow, we'll have a decision to make as far as where everyone's at with their investigation, okay? I'm probably not going to talk to the state attorney this afternoon, so when I talk to the state attorney, it'll be in tomorrow morning.
Why would you talk to the state attorney if I'm telling you I don't want a plea deal?
Because I'm going to keep all offers and all options open for you, okay? So I am not going to take an aggressive stance with the prosecutor regarding potentially him making an offer to you, okay?
My second time coming to your office to meet you was February of 2015. My brother was here. And you told me and my brother that the only way that you could speak to the state on my behalf to look for any plea deal, to come to some sort of agreement or compromise with the state, was if I gave you permission to do so.
Well, that's changed somewhat.
Why? Are you telling me that there's a law that says you can do that, or that you can't do that without my permission?
Circumstances have changed in your case. And
what law? I'm just trying to get you to point out the statute on it.
There's no statute.
Okay.
That being said, I'd like you to be in court at 8 o'clock tomorrow, okay?
8 o'clock or 8:30? I'm on the docket for 8:30.
8 o'clock.
Why 8 o'clock?
Because it's always important for a client to talk to their attorney before you appear before the judge.
Okay, so we're talking now.
It's always going to be 8 o'clock. Anytime you have court, I want you to be there at 8 o'clock.
Okay, but what do you have planned for us to talk about? So
I
can prepare myself to bring my video recorder, this report, the discovery, evidence, recording.
You can bring it all. And be prepared for everything. But be there at 8 o'clock, okay? That way we'll have a few minutes to talk before the judge takes the bench. And I just told you that there is going to be a discussion.
And what is tomorrow? What is that for? Pre-trial, or is it another Nelson hearing?
I'm going to answer that question after I finish what I was saying, before I was interrupted. If you're there at 8 o'clock, again, what I pointed out is that I'm going to have a discussion with the prosecutor. I want to relate that to you before you get in front of the judge at the podium, so you're not hearing about it at the same time that I'm telling the court what's going on with your case, okay?
But what would you
tomorrow,
have to discuss with the prosecution to tell me? A plea deal? But I'm telling you I'm not going to take it.
Potentially. And you shouldn't lock yourself into a scenario either.
Okay. Now, I have one question about this Nelson hearing. What exactly, because I thought I was going to pre-trial on the 22nd, but it turned out it was called a Nelson hearing. So what is the difference between a pre-trial and a Nelson hearing?
No, did they mark on your stamp out Nelson hearing?
That's what the judge said. Maybe he was talking about another case. I don't know.
Well, I think that's
But he also said motion denied, and I didn't file a motion that day.
Well, you made a complaint to the court about my performance in a case, and he conducted a short Nelson hearing. A Nelson hearing is to determine whether or not you're receiving effective representation during a period of your case. And
no, I did not. I told him, I said, I've already tried to have you removed from my case by filing.
And he informed you.
I never filed again.
And he informed you that you can represent yourself if you want to.
That's the only option he gave me, even though I had not filed. I had not written a motion.
If you want to take that option, you can let the court know about that tomorrow, okay? But that being said, please be there at 8 o'clock, okay?
And also, one other thing, have you listened to the 911 recording?
I listened to the CD. Your CD is right here. I listened to it.
So why is it that you have not...
version of it too.
It's the same thing. Why is it that you have not received a copy of the 911 recording from the state attorney?
Because what you're proposing that I do regarding this would not help you at trial.
Okay, but you just implied that my CD differs.
No, I did not.
Okay.
No, there was no implication.
So how would you know if that's accurate? How would you know that I have not changed that? Because I gave you a copy of my copy.
It's irrelevant if you changed anything. It's just the purpose of putting a 911 recording into evidence is not going to help you. It only supports the state's theory. It only gives the state an opportunity of hearing Miss Valentine talk about what happened to her without her having to take the stand.
Did you hear me at all on that tape?
I don't think that what you have to say on there is helpful either.
What did I say?
Ma'am, if you want to talk during your trial, you're going to have to take the stand, okay? And what I've already said to you is if you take the stand and tell the jury your account of the events, the state attorney is going to shred you in front of the jury.
And what about the Percy Wingo case? Have you looked at his discovery and his transcripts from his trial?
Whose trial?
Percy Wingo, her uncle, where she testified and I gave relevant, competent testimony, and he was sentenced, convicted and sentenced to 20 years.
Okay, tell me more about that.
August 2013. He broke into my house April 30th, 2012. August 2013, a year and 4 months later, he's convicted. My case has been going for 4 years. He was convicted in a year and 4 months.
Okay.